Everything you are about to hear comes from public records, court documents, and official statements. No theories, no speculation. Only what was confirmed and what was quietly ignored. In July 2019, Jeffrey Epstein was arrested in New York on federal charges related to sex trafficking. This was not the first time his name had appeared in court records. More than a decade earlier, similar allegations had already been documented. What made this arrest different was not the charge itself, it was the timing, and the amount of information that suddenly became public. Epstein was held at the Metropolitan Correctional Center in Manhattan, a federal facility designed for high-profile detainees. According to official records, he was placed under special housing and monitoring. Less than a month later, he was found unresponsive in his cell. The official ruling was suicide. That conclusion came after internal reviews and medical examination. What followed was an unusual release of documents, not classified files, not secret intelligence, but court records that had existed for years, rarely read, rarely discussed. These documents included depositions, civil filings, and sealed records that were later unsealed by court order. They did not introduce new accusations. They did not deliver final answers. What they did provide was something more subtle: a detailed timeline, and a series of inconsistencies. One of the most misunderstood aspects of these files is the presence of names. Being named in a document does not mean being accused. It does not mean being charged. It means exactly one thing: that a name appeared in legal records. Courts made this distinction clear. Many names were included without allegations, without evidence, and without legal consequence. This is not interpretation. It is how the law works. Yet public reaction rarely made that distinction. Another detail often overlooked is how long many of these records had existed. Some depositions were taken years before they were unsealed. Some filings were available through public databases, read by almost no one. They were not hidden. They were simply ignored. There were also discrepancies in timelines, not contradictions, but moments where official statements did not fully align with earlier records. Times, procedures, oversight, internal investigations later acknowledged failures, staffing shortages, protocol lapses. These admissions were documented. They were not speculative. Still, many questions remained unanswered. Not because the answers were forbidden, but because they were never clearly addressed. This is where the story often changes tone. But it should not. The most important fact in the Epstein files is not what we assume. It is what was officially recorded, and how quickly attention moved on. No final conclusions were reached. No broader cases followed. The documents remain public. The record is complete. But the discussion is not. And the most disturbing part is not what we do not know. It is what was confirmed and then forgotten.